Good morning, Brother Call.
Morning, Chief.
Good. Apropos, my lord, yes, last hearings, my lord, conclusion, my lord, where the issue was some genuine human concerns. And, my lord, the discussion was that something can be done administratively. Lord, I have taken instructions, my lord,
Yes.
and government is positive, my lord. What we have decided is, my lord, of course, subject to your lordship's approval, my lord, this would need coordination between more than one ministries, my lord. So therefore, a committee headed by no less than the cabinet secretary will be constituted. My friends can give me the suggestions or the problems which they are facing, which, my lord, the committee will go into and will try and see that so long as possible, so far as legally permissible, Lord, they are addressed.
So what we can do, since we are still in the midst of the arguments, after your side is concluded, and when they come up in rejoinder, or even before that,
They can give me
request-
today also,
right? We can. They have the weekend because after today, then we go on to
Tuesday, my lord.
Tuesday. So in the meantime, they can give to the solicitor, and the learned attorney, a set of ideas or suggestions which you have, and this is without prejudice to your rights in the rejoinder. Please don't feel it other way that we are.
It won't be used as pleadings or anything, my lord. It would, therefore, I say give it to me.
He has a little time. They have a little time to apply their mind, and then take a call on that. So that's one thing which we can possibly therefore. Mr. Solicitor, very valuable suggestion from my learned brother. What we could do and contemplate is another thing, that if both learned attorney and you and Mr. Dwivedi, Ms. Bhati, Mr. Datar, who are appearing on this side, could maybe have a meeting with the council, because you're brushing shoulders every day in the court. So if you can all sit together and have a meeting maybe on Friday or Saturday, and at the meeting, of course, they can formulate something and give it to you and have a little discussion with you so that the meeting will not be under any formal color of authority or something, just an informal meeting.
They are most welcome, my lord. We would be hosting them. There is no difficulty. But only difficulty would be, we may not have ready solutions, my lord. We means lawyers.
I understand, because you have to go to you said that the government will constitute a committee chaired
they
by
will
the
have to,
cabinet
my lord.
secretary.
Well, it's a meeting. If I just take 30 seconds, well, meeting is not a problem. Even suggestions is not a problem. I heard my learned friend say administrative. Well, there are 2 points to be kept in mind. Of course, your lordship is kind enough to say without prejudice.
Abhishek,
There are very substantive issues of law which are involved. Obviously, all this is without prejudice to that. This, at the best, what is being suggested is administrative tweaking where necessary in a committee based on suggestions. Legal tweaking is another system. The laws are involved in many places. So what we'll do is we'll confer. Without prejudice, we can certainly give. But personally, I don't think that your lordship will have any major solution. Having seen the gamut of problems and the level at which conceptually and jurisprudentially matter has been argued, I think it is better that you should spend so much time to go on to a decision. But we will certainly give this. This can be an addition. Anything tweaked administratively and helping is always a help.
Because
I think, sorry, Dr. Kungi, look at it as a one or none. Because although he's saying administrative, there are substantive issues here. When you're looking at insurance, your housing, etc., these are as substantial in terms of the benefits that people can expect. That is actually the practical way out. What are the barriers which you're facing? That those barriers you should give it. If there is a frank discussion out of that, although this is being termed as administrative, this will have to translate into some changes in the regulations, maybe even law.
Well,
So to what extent they are willing, to what extent?
Certainly, but the word administrative I said was that many of them will require substantive changes to law, which I don't think is what my learned friend is saying. What he's suggesting is that a circular may be changed. Office order may be changed. I may be wrong.
No, no,
I'm
that's
just
not the
expressing
intention.
without
That's-
thinking of what I learned.
Whichever mode, method or manner in which that problem, if permissible, can be, my lord, addressed, that's, my lord. There is no existing rule which
Dr. Singhvi, let's come down to some example. I think Dr. Guruswamy had made that the chart
Chart is there,
containing
chart is
or even you had presented a chart of the
Changes.
seven items. Some of those don't require substantive.
So
change.
therefore, Malas, certainly.
Now, sometimes beginnings are small.
No, Malas,
So
certainly.
Those beginnings could be very substantial in that
Malas,
sense.
I bow down. Beginnings are small is absolutely opposite, Malas. Whatever little is given by administrative tweaking, certainly it would be welcome. I'm only saying, Malas, that this should be seen as a constructive effort towards a convergence. It may not, Malas, be a substitute for the larger. That's all that I'm saying.
But Dr. Singhvi,
Yes.
one step at a time, while the matter is on,
Yes, yes.
suggested that we
Immediately, Malas, I started by saying that. We
look
will.
into it,
we
and
will-
maybe if there is any statutory tweaking required, depending on the kind of needs that have been highlighted by.
Yes.
Be open to look.
What
We are, my lord,
What-
right
what
now,
we
my
will
lord,
do,
not
Malas-
aware of what we are dealing with. Suppose there, as my lord, very rightly, my lord, pointed out, that it might need change of law. And change of law might need, my lord, some wider issues of recognition of a particular relationship. Then, my lord, we will have to examine whether that can be
So
done.
therefore,
Also,
But, my lord,
also, Dr. Singhvi, the way we are looking at it is that from the drift of the submissions which were made by the learned solicitor on the last occasion, it appears that the solicitor also accepts that, of course, people do have a right to cohabit, and the right to cohabit itself is something which is now an accepted social reality, at least. Based on that, there may be certain incidents of that cohabitation. For instance, in relation to your right to reside together. Second, bank accounts,
Insurance.
insurance policies.
Provident.
These are practical issues which can be resolved by the government. From your perspective also, this is a step forward.
Absolutely, Malas.
You see, therefore,
For example-
therefore said you don't have to go for an all or nothing
So,
approach.
Malas, then when I.
Lord,
I
for
think-
example,
I
Lord,
think-
two persons, two old men are staying together. They are
No,
not
Malas, can I just-
necessarily
No, my
in
lord,
any
I
gay
think
relationship.
That,
For
ana-
companionship, for looking after each other,
my
etc.
lords, that analogy misses the point. It does not take an assertion of rights for two adults who are self-sufficient to live together. That is an exercise of free will. Rights is a proactive, positive enactment that the law recognizes. There is a distinction here. So an old man being taken care of by a caregiver misses the point.
No, but that's
No, not
when-
caregiver. Two
are
people,
not
three
exactly
people
all.
staying
Let me
together,
just
they
give an
want to
example.
share their bank accounts, their
We
insurance.
are not, we are talking
See whether
specifically of
it's
same-sex
it's a
relationships.
caregiver taking care of a person under his care or a relationship where you're claiming these rights. Practical effect would be that the
You're
caregiver,
cohabiting.
yeah, let's say the person who is the one who is being cared, he is neglected by his sons, he is neglected by his children or other relatives. He does not want to give it to them. Now, short of creating a will, in case he dies intestate, if he has a nomination, he cannot nominate this. See, today.
Be a part of, say, medical insurance. He
I-
wants
I
to
bow
be a
down
part
this,
of medical insurance.
But may I just say this, for something as simple as pension, provident fund, gratuity, benefits, that accrues only in a marriage. It does not accrue to the caregiver. What accrues to the
That
caregiver,
accrues in a
even in
marriage,
other
but Dr.
systems?
Guruswamy,
That's the
that
reason why
accrues-
one is putting forward this idea.
Exactly.
Yes, my lord.
And that accrues in a marriage because of the nature of our rules.
Correct.
Well, it's
If
very
you have to,
sensible.
therefore, that's something exactly which the government has to consider.
Well,
And that's
nice
why
one
we
thing.
thought.
Suppose
that there should be-
hypothetically, I do not know, my lord, what
Well,
will be
we
the
will do
implication.
one-
My lord, suppose the government says that nomination in case of provident fund would be a family member or anyone else which the retiring person chooses to. No, then you don't need to go into anything else, my lord, the problem is
Let
solved.
us be clear.
So
Just one
sometimes
minute.
solutions
one
are, my lord, simpler than the problems.
Malas,
See, Dr.
to be
Singhvi-
clear- To be clear, when you,
Justice Paul-
Justice Paul is saying.
One second, Justice
Paul is-
Paul wants to say something.
Dr. Singhvi, please notice, as my brother colleague said, this is without prejudice to everybody's rights and contention. One. Number two, even if the court was to, suppose you were to succeed to a limited extent, and the court was inclined to give you a status of a marriage or inclined to give you a status of some other status, let us say not marriage, but some other status, there'll be many changes required in administrative proceedings as also legislative aspects. Therefore, if there is a consensus, at least whatever be the status recognized, after all, they are not denying that this is an incidence of society which is happening. They are reluctant to give it a status of marriage, but they are not. I believe from what solicitor says, reluctant to sort out the problems arising from a gay companionship without labeling it as marriage to the extent possible. Now,
May I respond just one
So it's
second?
not gay. There are several combinations. I don't wish to go into.
Mr. Solicitor, let the
It
learned
becomes
judge-
unmanageable, my lord, to
complete.
fathom
See,
the
let me-
Let the learned
possible
judge finish.
combinations, my lord, which can arise.
Let the learned
Let me
judge
complete, Dr. Singhvi.
All
Let me
is finished.
complete. Yes. Therefore, what is the suggestion from the bench is that the nitty-gritties of what may in any case be required to be done in either situations, some endeavor or step is taken in that direction. I think that's what Justice Bhatt and the Chief Justice put. So
Well,
I think let us, without prejudice to anything else,
Absolutely.
sit with pre-notions or prejudice notions on either side as to what
Well,
can be sorted out.
I
Without
start with
prejudice
that.
to both the contentions. My
Mr.
contention,
Solicitor, 1
their
minute,
contention.
please. Whereas I start with that, give me just 2 minutes. Your lordship may take it. I started with that. And I'll do better, Wallace. I'll try and make a chart, which is actually 3 categories.
Right.
And a fourth is, Wallace, conceptual. Give me just 1 minute. One category, clearly, possibly solvable immediately, is the so-called administrative tweaking, which is followed from my lord, Justice Bhatt, Justice Kaul just now. Surely what you can get by easy tweaking, there is no question of looking a well, gift horse in the mouth for no reason at all, just because we are on some principle. Of course, it should be cooperating. Of course, we'll give that. A second category may be something more than that. A third category may be substantive, bigger changes. I'll try and identify them separately. But Bolos, above all these three, so the first category, Lordship will take it. People will meet up. People will make a list. People will share it with the solicitor. We have no problem. We have no ego about it. The fourth idea is important for lordships, and only your lordships can decide it. That is the real, the symbolic, the actual meaning of marriage. That nobody can decide except this court, this way or that way. No Malus committee, no circular, nothing can. Now that's the
Parliament
juristic
can.
question. 1 second, Mr. Solicitor, 1 second. That's the juristic question. Now, therefore, we are, as Justice Kaul said, Malus, we are happy to divide it, and what might be called low-hanging fruit
Yeah.
benefits everybody, Malus. Everybody eats that fruit. Of course, we'll cooperate. The other fruit, Malus, will have to depend on some kind of an order. And we'll make that categorization to the best of our ability.
Equally, Dr. Singhvi, when we go into the conceptual domain,
Yes.
we cannot be oblivious of the fact that to the extent to which the conceptual domain requires legislative changes, that part clearly lies outside the
Part of the
remit of the court.
dialectics, Malus. That will be part of the dialectics.
Then the question which the court will have to face is to what extent does the court go in formulating conceptual doctrine?
Yes.
Absolutely.
Because ultimately, whatever doctrine the court formulates has to be relevant on the ground. All right? Therefore, there may be 3 levels really. There may be certain areas which are governed by pure administrative, changes.
That's what
which
I
can easily be done by them. Second, changes which they accept as a matter of principle, which may require changes in some form of
Regulation.
subordinate regulation.
Subordinate.
Which again is a matter for the government. They don't have to go to parliament for that, which is again much easier to achieve than say a parliamentary change in legislation. The third is your wider,
Exactly. That's
your
what I would
widest
do.
case, your fundamental point is that, well, there is a right to marry, one, with reference to constitutional precepts, even for same-sex couples. Second, that you can found that or source it in the Special Marriage
It's
Act.
not a
That's what-
hollow right. It's not just a
That
shell.
is what you have all
table.
argued. That is what you have all argued. That's something which we will have to ultimately decide, subject, and therefore that's
it,
what their
that's all
argument
that I'm
is.
saying. That's all that I'm
That
saying.
this is essentially a legislative arena. Don't step into this.
Dr. Singhvi, yes.
Therefore, we are saying that, well, we will of course have to decide it. We are going to decide this entire issue as a matter of concept. But to the extent to which the government takes a first step forward,
Absolutely.
there would be a substantial benefit, a substantial advancement in the recognition
It's a
of
welcome
what is
thing
the
and we welcome
cohabitational
it.
relationship of same-sex couples in the country today, which would be a substantial advance beyond what we have today.
Yes, yes, yes. I will certainly have no
This
such.
is exactly the point. I would put it like this, somewhat like this, a bit differently, which is that Dr. Guruswami and I think Mr. Kripal, all of you in different ways said that, this could be a part of a series.
Part of a?
Part of the
Series.
series, or whatever you want. Look at it from the reverse. If this results in a gain, maybe not as substantial as you visualized, right? That's one of the building blocks for your future, No, do you want a ruling then? That too is something you may have to consider, given that you're now not really fighting a battle only for these petitioners, but there's a larger group of people who may not be covered by this dialectic of Special Marriage Act. So then, is it advisable or prudent, if you're going to get this, to continue with that larger, push?
So we'll build that
too,
into
you
our
have to
argument.
make that, take that call.
We'll reflect on that and build that into
Yes,
our argument.
we'll
We
bring
well
it in.
fully understand what my lord is saying. Fully
Can
understand.
can I say one thing? Mr. Grover is
Only one
not
request
doing
I
it,
would
but certain
make.
people who are not in that part of the dialectic. Because we've all gone and spoken in seminars, and there are people who believe in the absence of heteronormative institution of marriage. And when one goes out and meets 99% of the people who come up to you, they all say only one thing, that they want to get married.
Yes.
Because the consensus within the community, no matter how many people may say that it is a concept that they otherwise reject, is that they wish to have marriage.
Yes.
Because this gives meaning, purpose, identity to the people who are seeking to get married. Because it is, and my learned friend will agree with me. So it's not correct to say
Yes.
that there will be people who will be out of the bound of marriage, who don't want marriage, but they are happy with something else. I, Millets, personally, and I'm sure Ms. Guruswami and Ms. Grover as well, in all the multiple meetings we've had,
Yes.
we hold some academic discussions of
Yes.
people who say, no, it's a heteronormative institution, it's not necessary. The vast majority of the young people I have spoken to
Yes.
have all said, we want to get married. The parents of those young people have said, we want to get married. Because we say we want to get married. Why should we be second-class citizens? Because there was a time we were criminals, then we became third-class citizens. Now they're saying be second-class citizens, then be content. That is not what the Constitution promises.
Yes.
So that's the third category. Well, I am not belittling your lordship's first or possibly second category. Please don't misunderstand that. All of us here, but we are all imploring your lordships to recognize a third category,
Yes.
incapable of partial minimal resolution by the Solicitor General.
Just-
Incapable. But the first or the second, yes, we'll fully cooperate.
And one exercise we've also undertaken.
My lord,
And we'll
just-
keep
but I
that,
just-
Bhatt,
Yes.
that point in mind, that whether we can give up something, not give up, that part, I
And
understand.
ultimately,
No, in the sense, that it can be tailored. No, for us, tailored.
My lord,
Can I
but
suggest also,
just,
we amongst ourselves, all the petitioners are sitting down and we are trying to make some kind of a draft of what is it that we can hope to achieve. So there's a consensus in ourselves. We understand we can't get everything. Because we will put forward some idea of what is it that we hope that this court can give
that's
us.
exactly why we thought that some
Well,
sort of
that is
meeting of
That's
some
our
exchange
concept.
of ideas between all of you would be helpful.
Consensus is amongst us already that at least Section 4 recognition of marriage has to be given. What rights follow from that, when, how, those modalities.
Yes.
So that is legislative. No, therefore, my lord, I would request.
May I just say this, my Lord Justice Bhatt? When I speak at different events around this country, I make it a point to speak in small towns India. And I make it a point, and young people in our country want marriage. I don't say this as an elite lawyer. I say this having met these young people. Do not let them experience what we have experienced. Every study indicates that in countries where there is marriage
Let's
equality.
conclude on the marriage.
Dr. Guruswamy, there's a problem with this line of argument.
No.
I'll tell you why. We understand the feelings out of which this argument comes. But at a constitutional problem, at the constitutional level, there's a serious problem. If we go by what young people feel as a constitutional court, then we would be subject to volumes and tomes of data on what other people feel. Now, therefore, the great salutary safeguard of constitutional adjudication is that the court has to go by what the Constitution mandates.
Correct.
And therefore, we don't go by
Yes.
either popular morality or a segmental morality. We decide what the Constitution says.
But this is
Because the moment you say that this is what young people feel, I'm sure there'll be people on the other side who are willing to throw tomes of material at us on what the country feels.
Lords, my only,
Let's not get into it at all.
my lords, this.
Therefore, what we were suggesting was this. We get your point that you seek a right to marry. You're also conscious of the fact that a mere declaration of a right to marry is not adequate in itself unless it is implemented by a statutory provision which recognizes, regulates, confers entitlements on those who are married. Therefore, you are conscious of the fact that the implementation of the right, the achievement of progress on the ground depends on whether there is a statutory framework for implementing that right. And therefore, you say located in section 4. We'll consider that argument. But as we said, suppose we were to come to the conclusion that this argument is not as simple as it appears to be, that there are too many interlinkages with other statutes, including personal law, which we would be treading upon, and perhaps which would lie outside the domain of judicial review. Then what? Then our concern is that, look, everything has to be something which you achieve in incremental steps. This is a social institution. That social institution is also evolving over a period of time. But the court can ensure by acting as a facilitator that real progress is achieved today in terms of a wider societal acceptance of the right to cohabit together. Whether we go as far as to recognize the right to marry for couples who are not heterosexual couples is a separate matter. We'll be dealing with that. We are not shutting the argument to you. That's why we are hearing this side. But even assuming that we don't, we do, that's the end of the matter. But if we don't want you to be in a situation or the movement to be in a situation where there's nothing else then available in hand, that this matter then goes. That's not the way we are couching this, this dialogue.
See, if you've seen the history, and in this side, you're all acutely aware of the history, you know better. You've seen the ups and downs of that for the last half century and where it went to, what kind of legislation came, not positive, mostly negative, and how finally you got the judgment that the US Supreme Court gave. Now, you are circumventing all that. Of course, there is a lot of, let's say, feeling in this, a lot of felt, experiences in those. Nobody is discounting that. But if you do gain something out of this, that's a big positive. Because, I mean, there are so many processes outside of what we can speak in this country and in society generally, that these gains are also not to be belittled. Now, if you're likely to get it, I mean, just sit back and think what you're gaining.
Yes.
And then if you are still pushing ahead and you want that declaration, we will have to examine it. And even this closure or whatever, if this happens, I mean, this is completely, please let me complete. There is no closure. What I'm saying is, if there is some quietus to this at this stage, don't see this as the end of the battle or whatever your movement is. Because ultimately, whatever your movement for equal recognition of equality of, that would always remain. And even if these, whatever you get, the positive part of it, even if you don't accept this or partly accept this, now that too will not be the end for whatever you are going to do. One is speaking generally, not in any manner prejudging it.
My lords, in Obergefell and in America, the experience was that after Obergefell, when the Supreme Court gave its broad and firm declaration, the counsel for the parties then sat with the government, with the administration, and went through each law. And each department sat with them and they went through each law. I'm told it's 710 laws or something, and then sat down line by line and sorted out post the declaration in Obergefell.
But that was a different kind of, let's say, working out, because they had to work out what was unconstitutional. Oh, we are literally putting the alphabet together.
Yes.
That much harder.
But my lord,
And
the
even
only thing
Malad,
And not
there
only-
are good
not only
reasons in
mere
the
laws, there
minority
were
views also.
constitutions. There were constitutions which had to be invalidated.
But my lords, the only thing I will say
In
is that
fact,
we as
in
a
Malad,
jurisdiction,
this
we-
judgment my learned friend is relying upon,
we as a
there were
jurisdiction,
restrictive
constitutional-
statutes which came before the Supreme Court.
But we as a
Some states had
jurisdiction-
Now,
jurisdiction.
Mr. Solicitor, coming
My
back
lord-
to your submission,
Yes,
let's get
right.
on with that
Yes,
in
that's
another
right.
10 minutes. We'll put
We have a
We'll put-
rejoinder.
We'll
reflect
put the
on-
next
yes,
batsman
please.
in,
We'll deal
and
with
I believe the
Yeah,
next
Manoj,
batsman will
only,
be learned
Lord,
batsman
only
will be-
one request, Lord, to the other side. While giving the suggestions, Lord, I would request them not to give jurisprudential ideas, etc.
No, no, not at all.
Only-
That's for
Of
us.
course not.
Only
Second and third
factual
category.
problems
Obviously.
which can be addressed by the
Jurisprudential is for this
administrative
side,
magistrate.
but not that side.
There's no delegation of the judicial power of the court.
Yeah, yes. That's
Jurisprudential
no,
will be
there
decided.
can never be, Manoj, there can never be. A lot of
Think we'll
shoulders are the strongest, Manoj. But it may not happen, Manoj, that the committee doesn't understand what the issue is. Let it be as simple as possible. That's all.
little legal training.
Mr. Solicitor,
Make it very
we've
specific.
now heard your submissions. We are now almost at the wrap-up point of your submissions. The jurisprudence which we have considered and, your line of submissions, I think there is an area which even according to your submissions then that the court can go into, namely to recognize that same-sex couples would have a right to cohabit together and cohabit together in a normal, peaceable environment in our country without any form of discrimination, either societal or otherwise. Step two, that the government would, as we now see from your very fair suggestion that the cabinet secretary, no less than the cabinet secretary would be going to it, would be recognizing the incidence of that cohabitational relationship. So we can certainly build upon our jurisprudence as going to that level. Question now is, and we don't want to stop them, whether we make that extra mile, which is what they have argued. And we have also argued that, look, this part would be a legislative exercise, don't step into that. So now what else remains? You can now
Lord,
wrap
can I
up in 5
conclude
minutes
in
so that we can
15
have
minutes?
someone else.
I'll wrap up in 15 minutes, Manoj. Lord, I have filed one note. I'm not going to read it, Manoj. At the outset, I may put that caveat, Manoj. But there are only 3 points, Manoj, which I am making. Manoj, note 3, Manoj, it's circulated yesterday.
History note 3?
Note 3, Manoj.
You sitting when I was arguing.
Well, I'll just give broad propositions and I'll not read it, Manoj, what is not relevant. Manoj, my first point that recognition of marriage is not a fundamental.
There's a note one.
I'm so sorry.
नहीं,
Manoj.
उसके नीचे है.
Note 3, Manoj.
Notes by Mr. Mehta.
उसके बाद नीचे है थोड़ा सा.
Yes, so that's this.
No,
Note three.
last time.
Yeah, this was cited last.
The title is closing points.
Closing points.
My lords are
No, closing arguments. Closing arguments.
closing points.
उसके नीचे.
Yeah. Closing arguments.
Yes. And my lords, my lord, I am obeying the continuing mandamus, my lord. I am
This one.
using the iPad, my lord.
That's good.
So a weak student, my lord, in at least schools I studied, used to get 5 extra marks for good handwriting. My lord, I need 5 extra marks, my lord, for using this one on the lighter side. My lord, my first proposition is right to get a particular social relationship recognized as a marriage is not a fundamental right, my lords.
Let's read it quickly. Let's read the note.
Yeah, yes, but I'll just quickly, my lord, go through. It is submitted that over and above marriage, there are a whole host of human relationships which exist in society, which may in some cases be even more valuable than marriage. The statutory law in any country in the world does not regulate all human relationships. The said relationship may be extremely important from the perspective of life and liberty and the dignity attached to it, and may further even have a more profound impact on the life of a person. However, sans a legitimate state interest, legislatures across the world have left a whole host of human relationships completely outside the legislative purview, denying any legal recognition to the same. It is submitted that the presumption, therefore, cannot be that the state is obliged to recognize all human relationships. Rather, the presumption has to be that the state has no business to recognize any personal relationships unless the state has a legitimate state interest in regulating the same. Even for heterosexual couples, it's their intimate relationship state had no business to regulate or recognize. Why the recognition came? Marriages used to take place even prior to 1956 because the court felt that we will have to regulate. You cannot be at free will marry at any stage, any time, at any age. You cannot marry as many times as you want. You cannot just say bye-bye and leave the relationship. You can part with your spouse only on certain grounds. When you are in a relationship, the children might be there. Who will take care of the children? So the question of custody needs regulation. Who will pay the alimony to whom? So alimony provisions came. So state should step in only when the state feels that it is in legitimate state interest to regulate a relationship, and therefore recognition is only a consequence of that decision. Lord, hypothetically, Lord, para 3, it would be possible for a new religion, Lord, suppose new religion comes, to provide for a new form of marriage and new ceremonies for the same within the heterosexual fold. Lord, marriage, Special Marriage Act or Hindu Marriage Act doesn't provide for any particular mode of marriage. Except, Lord, in case of Hindu Marriage Act, it is that Saptapadi, etc. But suppose, Lord, someone just garlands each other in a temple. Yeah, it's a valid marriage. Lord, would a new law providing for a new mechanism be under an obligation? New religion providing for a new mechanism of marriage be under an obligation that would be having a right that the legislature must accept that kind of a marriage as well? The answer would be no. My Lord, thereafter, my Lord, my Lord, second, I'll not, my Lord, read except, my Lord, the argument that marriage is a fundamental right was essentially based upon two judgments of your lordships, my Lord. One was Shafin Jahan and another was, my Lord, Shakti Vahini. My Lord, in none of the judgments your lordships were even remotely considering right of non-heterosexual couples to marry. My Lord, in Shafin Jahan, please remember, my Lord, the facts. One lady, Hadia, a Hindu girl, converted into Islam, was seeking to marry a Muslim boy, and the family of the girl were objecting. Non-state actors were objecting. There, your lordships, my Lord, in a habeas corpus jurisdiction said that it's their right to marry because they are heterosexual couple, and your lordship specifically said that Muslim personal law allows the marriage. You have no business. The presumption was that it was a valid marriage recognized by the law, namely the personal law, Muslim personal law. Your lordships, my Lord, never remotely considered marriage as an abstract proposition to be declared a fundamental right, or marriage amongst non-heterosexual couples as a fundamental right. Your lordship.
Mr. Solicitor, conceptually, there's a little bit of difficulty about this argument. I mean, we understand the drift of the submission. Their argument is not that the state is duty-bound to recognize all relationships.
Yes.
You are saying that, look, there's a gamut of relationships in society. The state is not bound to recognize all relationships in society. Their contention is that by not recognizing same-sex relationships for the purpose of marriage, the state is acting in a discriminatory way. So the argument is really of the anti-discrimination principle, not so much that the state is bound to recognize it or recognize all relationships in society. They say that marriage is a very vital social institution, step one, that same-sex couples are entitled to the same right to dignity as heterosexual couples, and not recognizing that relationship within the fold of regulation would be to deprive them of all the societal benefits which attach to marriage, and therefore it's discriminatory. So that's the line of...
To which, my Lord, I don't wish to repeat, but, my Lord, just to paraphrase once again, my Lord, our respectful submission, my Lord, is that this is a reasonable classification.
That's fair, and that you have made your point.
I have already made
now,
it.
Shakti Vahini and this you have dealt with in point 5, right?
Yes.
You want to read that, or you have dealt
Lord,
with
only highlighted part, my Lord. Your lordships may come to page 3, my Lord.
Page 3, all right.
This is quotation from, my Lord, Shafin Jahan.
Okay.
Where your lordships are very careful, my Lord. The only highlighted part, underlined part. But the High Court unwarrantedly took exception to the same, forgetting that parental love or concern, my Lord, daughter's parents, my Lord, whose girl converted into Islam, concern cannot be allowed to fluster the right of choice of an adult in choosing a man to whom she gets married. That was, my lord, the broad conspectus that law permits a marriage between heterosexual couple. One is man, one is woman. The family has no business to interfere. Then, my lord, in Shakti Vahini was a different case.
That was a Khap Panchayat case.
Khap Panchayat, my lord, completely state actors, either by making regulations which they were not permitted to make, or by honor killing and other, my lord, extrajudicial unlawful means they were preventing. And, my lord, at page
can go
4,
to
if your lord...
point number 8 of your submission, where you have summarized what you're now saying.
Yes, my lord.
Therefore, it is submitted.
Yes, my lord. Therefore, it is submitted that said judgments were given in the context wherein state or non-state actors hindered the choice of a woman to marry the man she wished to. It is submitted that therefore there was an invasive positive act by the state or non-state actors in disallowing the exercise of choice in a heterosexual relationship despite marriage between them being recognized by law. It is submitted that said judgments are not, my lord. Then, my lord, kindly see, I'll not read it, my lord, but this Brown versus Board was cited by Mr. Vishwanathan. My lord, just to argue the separate but equal theory. My lord, this was a case similar to, my lord, what the situation was in India prior to independence with regard to some section of the society. They cannot sit in the same compartment. They cannot sit in the same place. There were different, my lord, provisions made, different classifications made for blacks versus white. So it was a racial discrimination. There was no intelligible differentia. And in that context, my lord, the Honorable Court said that it is not, my lord, your lordship's approach, my lord, para 11, I have, my lord, respectfully urged, my lord. Further, it is submitted that there cannot be a fundamental right, either under Article 14 or 15, to seek recognition to all forms of social relationships. It may be noted that the legislature does not seek to give recognition or any special status to all forms of human relationships. It is submitted that this Honorable Court ought to approach the present question not merely in the linear reductionist sense, as sought to be, my lord, made. This is, my lord, this is a classification made on the basis of nature of relationship. There is a reasonable nexus with the object. Object is the family, family as a unit, family having all incidents of the family, and continuation of the human race. So, my lord, I'm not, my lord, repeating. I have already made my submissions, my lord. My lord, Citizenship Act and Foreigners Act, my lord, was thereafter not pressed. But, my lord, for completeness, my lord, at page 6, I have, my lord, put my submissions. I don't wish to repeat because they also very fairly did not press much upon it, my lords.
But then finally, page 8 at the 8th
Page 8, my lord, your lordships, my lord, were pleased to require us to provide a comparative chart between, my lord,
that you have now provided.
that, my lord, that is provided for. And, my lord, last submission, my lord, please, if your lordships can come to my note 2. Only, my lord, few good, my lord, illuminating judgments of the European courts, which would assist your lordships, my lord, I missed. And I felt, my lord, after arguing on the last occasion, that taking 10-15 minutes of your lordship's time, I must, my lord, advert to those judgments, my lord. My lord, if your lordships have my second note on fundamental rights, my lord, at page PDF 76.
76.
And this is the last submission, my lord. I will not trouble your lordships anything further. But some judgments, my lord, would really assist your lordships.
The European Convention and its gradual development, that part?
Yes. Lord, may I read 142? In Europe, and the European Court of Human Rights has its seat in so-and-so and is tasked with the compliance by the member states of the European Convention on the Protection of Human Rights and Fundamental Freedoms. The European Court, in the manner, provides an additional forum to litigant to enforce the rights under the ECHR against the against the nation state, which is a member of the convention. The ECHR was entered into force in 1950 and is the main treaty which sets out the civil and political rights and freedoms of European states agree to ensure for people living within their jurisdiction. Lord, Article 8 is similar to Lord, Article 20, almost, Lord, not word by word, but peri materia. Everyone has the right to respect for his private and family life, his home, and his correspondence. There is a specific right to marry. Please see this, my lord. Article 12 on PDF page 77. Man and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. Now, two things. A, even European Convention recognizes a heterosexual marriage and it makes it subject to the national laws of each member state. Yes. Lord, therefore, the ECHR clearly recognizes right to marry under Article 12. Despite the same, European Court of Human Rights has still date refused to locate the claims of same-sex marriage under Article 12. The European Court of Human Rights had consistently denied all claims of same-sex marriages and still does not recognize marriage to be an enforceable right under the Convention. The European Court of Human Rights, after rejecting all claims for about 2 decades, has only recognized limited partnerships to be enforceable, that too in light of larger socio-political consensus in Europe. But this is not majoritarianism. There has to be a consensus on social issues. The said position is clear from a complete reading of the case law emerging from Europe. The European Court of Human Rights, for the first time, examined the issue of whether two persons who are of the same sex could claim to have the right to marry in the case of Schalk and Kopf versus Austria, and found that Article 12, the right to marry, of the convention did not impose an obligation on the respondent state to grant same-sex couples access to marriage. It was held as under, and I quote, the applicants were born in 62 and 60 respectively. They are a same-sex couple living in Vienna. Lord, kindly skip the Lord, para 50, kindly come to para 58 directly. The court is not persuaded, Lord, it's on page 78, para 58. The court is not persuaded by the applicant's argument, although, as is noted in the Christian Goodwin cited above, some previous judgment, the institution of marriage has undergone major social changes since the adoption of the convention. The court notes that there is no European consensus regarding same-sex marriage. At present, no more than 6 out of 47 convention states allow same-sex marriage. Then, my lord, para 60. Turning to the comparison between Article 12 of the Convention and Article 9 of the Charter, the court has already noted that the latter has deliberately dropped the reference to man and women. So, and so, my lord, I skip the commentary of the Charter, which became legally binding, my lord, that's for them, my lord, to para 62, 61 and 62. Regard being had to Article 9 of the Charter, therefore, the court would no longer consider that the right to marry enshrined in Article 12 must in all circumstances be limited to marriage between two persons of the opposite sex. Consequently, it cannot be said that Article 12 is inapplicable to the applicant's complaint. However, as matters stand, the question whether or not to allow same-sex marriage is left to regulation by the national law of the contracting state. In that connection, the court observes that marriage has deep-rooted social and cultural connotations which may differ largely from one society to another. The court reiterates that it must not rush to substitute its own judgment in place of that of the national authorities who are best placed to assess and respond to the needs of the society. In conclusion, the court finds that Article 12 of the Convention does not impose an obligation on the respondent government to grant a same-sex couple, such as applicants, access to marriage. My lord, similar is the judgment at page 147. I will not read it, my lord, but same court, lord, similar reasoning. Lord, if your Lord
This is later.
has relied upon this judgment, my lord.
दिखना है Sir, Solicitor, we've seen it. Yeah.
Your lordships have seen other judgments, but only one thing. Last, my lord. One page, para 148, my lord, that Oliari judgment which was relied
Yes.
upon. My lord, there the court, my lord, this was not read before your lordship, therefore it's my duty. The court records that in this country, there is a larger consensus. Whether your lordships would adopt that, my lord, doctrine or not.
After that, there was a law after that.
Exactly, my lord. Therefore, it
Actually,
was
there was a law, but they did not say marriage. They said same, I think it's a civil.
partnership. They said partnership. So, my lord, I am not reading, my lord, but I have collated all judgments on the point, my lord, and placed for your lordship's consideration. Lord, I'm immensely
Thank
grateful, my lord.
Thank
Lord,
you, Mr.
the
Solicitor.
learned attorney, my lord, would like to assist your lordship.
Yes, Mr. Attorney General.
I shared two notes by mail and also my separate compilations, which before I go into that, give me my copies to everybody. Please give copies to everybody. There's some broad reflections on a matter of such importance and magnitude.
Lord, I was required to convey, my lord, I forgot to convey at the outset. I received a phone from Mr. Sybil in the morning. Lord, today is little under the weather, my lord. So his absence may kindly be, my lord, dispensed with. His presence may be dispensed with, my lord. Kindly pardon his absence, my lord. I'm obliged.
Because I must say that I was greatly enriched by the submissions made on the petitioner side. I personally conveyed my appreciation of some of the deep insights which I received on a subject like this. And it will be, well, at one level, the court is engaged in a nobler task, we put it like that. For a different level, it is a matter where mere court engagement or engagement of counsel, howsoever enlightened we are on the subject and howsoever deeply committed to it, objective, neutral, and all that notwithstanding, the subject calls for if I put it like that, one, if you want looking at practical outcomes, an incremental approach. And if you have to go deep into certain fundamental constitutional questions, then ultimately one will find that you will not be able to answer them. Say, yes, this is the final answer. So that's where cases like this stand. I would probably continue with some line of reasoning with the learned solicitor who was placed before your lordships. And well, you look at the larger picture about how does the court take a stand on matters like this? On the one hand, we will have references from various constitutional court decisions from across the globe on certain principles of interpretation, which may seem to be on the evolving side of promoting human rights and fundamental rights and so on and so forth. Guidance has been repeatedly sought about. But if you look at the global scene, even looking at the Commonwealth, perspectives, you'll also find wide-ranging difference between the New Zealand approach and the English approach. With the New Zealand Bill of Rights and notwithstanding similarity between Section 3 of the Human Rights Act and Section 6 of the New Zealand Bill of Rights. So it's not that that we have a certain universal perspective on certain aspects of the matter on which there is no disagreement at all. Before I read my written note, I thought I'd like to raise some broad canvas of what I'm not to be taken that the court has no business at all to be engaging in this matter, in the sense, in a fundamental sense, because when matters of nature brought to the court, it's certainly the duty of the court to engage itself on unraveling the constitutional dimensions, if any, and to find out within the scope of constitutional deliberations, a possible solution can emerge without the court fundamentally altering the texture of the Constitution or the text of a statute, so on and so forth. So that's a basic line which the court would probably not keep it in mind and probably not breach, except for saying that, yes, this is a matter on which, because we follow a certain set of precedents like Vishaka, we look at how you fill in vacuum, etc. So all that will be essentially materials and resource for the court to take a holistic view of the matter. So if the court were to ultimately say, take suggestions felt today morning regarding whether the government cannot respond to a certain set of suggestions, which may probably address some immediate concerns, so one can certainly look at them. But what the executive can do within the possible legislative frameworks available today or going out of the existing legislative frameworks, and what the parliament can do, the lines must be very clearly drawn. So if the lines are not drawn, then perhaps there are other interminable consequences which will follow. So all that I say does not mean that the court will not probably deliberate on the subject. But at the end of the day, where the lines will be drawn is a very important question to be asked. So having said that, let me take your lordship through two of my written notes. Before I also do that, just to on a little abstract level.
There's one actually.
Learned, it's only one written submission that.
I have two written submissions which have been mailed to your lordships. I hope your lordships have that.
That's right.
We have the
There's
written submission. We have the written submissions. Okay. Yes, yes. There's an additional written note. Yes. Are we looking at the first one or the additional one right now?
I would have loved to take your lordships to some of the recent reflections by jurists across the globe, particularly, for instance, Habermas and Alexis in his very recent book on idealism and the law talks about how Dworkin's perspectives and Habermas' reflections have a certain difficulties in drawing final conclusions, like what Professor Lawrence Tribe talks about, the invisible constitution, and what we read in the soundings and silence. I'll probably take your lordships into some of them a little later, because they give us a broad perspectives on, while we have different constitutional frameworks and emerging from those constitutional frameworks, for instance, the 8th Amendment, the 9th Amendment, and all those the 10 amendments in the US Constitution, the Privileges and Immunities Clause in the US Constitution, the due process emergence, all that, as Professor Mark Tushnet says, the US Constitution is old, not easy to amend, and therefore somewhere somebody must have the job of interpreting the Constitution. I'll take a lordship through all that. Let me first read my first written submission. May read that?
Yes.
In the light of the summary of submissions made on behalf of various petitioners, it emerges the Honorable Court is called upon to declare that persons with non-heterosexual orientations and non-heterosexual classes of persons have a right not to be discriminated on the ground of sex and as regards the availability of the status of marriage and right to family enjoyed by heterosexual persons. We, by reason of the enunciation of law performed with the Honorable Court in so and so, the above said classes of persons have a right to dignity, identity, privacy, the autonomy of choice, and thus the right to enter into relations of family, the right not to be treated differently. Lord Justice Narasimha doesn't have that?
I'll drop it to you.
It's called
It's called written
written
submissions.
submissions on behalf of
By
the Attorney
AG.
General for India.
I have a hard copy. I thought.
We are a little allergic to hard copies.
That's not the idea.
It was sent.
Yes, yes. we can- Yes, yes.
Doing it. When it was sent? This was sent about 3 days ago. So the above said class of persons have the right to dignity, identity, privacy, autonomy of choice, and the right to enter into relations of family, the right not to be treated differently, accompanied by all consequential restraints against state and its authorities, as not to deprive them of all rights and benefits flowing from the status of marriage. And consequently, the statutory impediment to the realization of the above status enacted in Section 4 of the Special Marriage Act be declared to be either unconstitutional or to be so read as secured to them without any qualification. The same status of marriage is available to heterosexuals. Before I read further, a little digression. The other day, you was referring to the 242 Law Commission report
Yes.
about
Where you were a
freedom
member,
from- that's right.
attorney.
Even in that report, where I was a member in the commission, and I happened to write the concept note for that report. Even in that report, while writing that report, we had probably thought about this issue. And there is some statement why the definition of marriage may not be so enlarged as to include certain issues. The trigger point behind that report was about the Kap Panchayats and impediments in freedom of marriage as such. If you also notice that there is a statement about that, I'll come to it a little later. So para 2, it's canvassed that with a requisite redrafting of certain provisions of the Special Marriage Act, that's by a combination of declaration as to lack of attention to or non-inclusion of relationship other than the heterosexual unions vitiating the Special Marriage Act 1954, and declaring on the importance of securing to non-heterosexual unions a wide range of rights, claims, and interests attached to and consequent upon a marriage to follow, the needful will be done to bring about non-discrimination. The submission proceeds on the footing that with a minimal exercise of redrafting of the Special Marriage Act, by a process of construction and interpretation, all other measures can follow, either by necessary statutory intervention or by conformity by state and instrumentalities, with a declaration to be given by the Honorable Court. The following submissions are made in response to the above. The challenge to the Special Marriage Act is misconceived. The said law is a species of the general laws relating to marriages applicable to different faiths, religions, or sections of the community. All these legislations are instruments relating to marriage having the force of law, carry one common feature, namely the conception of marriage as a union of heterosexuals, and with procreation is an essential feature of such union as a family, among other aspects and dimensions important to such a union. Marriage as a union of heterosexuals has always been rooted in the family as a social unit. Heterosexual union is a feature common in many species. The Special Marriage Act is not a law based on a special and distinct conception of marriage outside the general law of marriage. It is not a law creating an institution of marriage. The Special Marriage Act is only a law in relation to the institution of marriage. It's a law conceived in aid of such a class of persons who may be otherwise disabled or obstructed in accessing the institution of marriage. It is thus a non-discriminatory legislation, not being in violation of either Articles 14 or 15 of the Constitution. The sole object of the Special Marriage Act being facilitating and enabling certain class of persons desirous of accessing the institution of marriage. It intends to provide equal protection of the laws within the scope of Article 14 of the Constitution. Being so designed, it has no discriminatory content. As stated above, the Special Marriage Act is an enabling and facilitating legislation based on the common conception of marriage as a union of heterosexual, the underlying premise in all laws relating to marriage. Marriage as a union of heterosexuals being the universal conception of marriage as such, the question of keeping in mind claims of other unions as marriage and to accord them the same treatment did not arise while enacting the Special Marriage Act. The debates in Parliament relating to the Special Marriage Act bear testimony to the above. As such, the Special Marriage Act cannot be seen in isolation or singled out for an attack on discrimination or unequal treatment. The Special Marriage Act 1954, therefore, cannot also be found fault with on the ground of under-inclusion. The test of under-inclusion or over-inclusion enters the debate only when all classes or categories of persons or entities relevant for a statutory purpose are conceived and identified, followed by inclusions or exclusions. The conception of marriage premise on a heterosexual union, coupled with procreation as an essential feature, stands as an exclusive conception. At the time Special Marriage Act was debated and conceived, an alternate conception of marriage of union of persons other than heterosexual union did not enter the picture, not because of design, or because of intent. It cannot therefore be stated the omission of considering or not treating the union of non-heterosexual persons on par with the heterosexual union in the Special Marriage Act is an omission to be constitutionally faulted and an omission amounting to discrimination. There was thus no under-inclusion, as if an alternate conception of marriage was perceivable but disregarded. From saying that the conception of marriage must now receive expansive connotations to accommodate all unions of persons as a family without reference to or conditioned by sexual orientations or factors, it does not follow that the prevalent conception of marriage as the union of heterosexuals was always narrow and weak. The question of updating a law can arise when the law in due course fails to realize its avowed purpose, not when an alien purpose is sought to be brought into the scope of the law. Based on the conception of marriage, common to all domestic laws and instruments of law relating to marriage, the Special Marriage Act has enacted a special scheme of provisions, particularly sections 19 to 21 of the Act, that the provisions of the Act have an intrinsic internal cohesion and no part of it can be severed. Similarly, by reason of law being premised on the union of heterosexual couples, all corresponding provisions relating to marriage, divorce and separation, etc., have also been enacted. It is submitted that the Special Marriage Act is not an impediment in the way of the absence of social recognition and the acknowledgement of a non-heterosexual union. The question is not one of the relevance and importance of social and legal recognition of the autonomy and choice of persons to live in chosen relationships triggered by their sexual orientation or sexual features. The question, however, is whether engagement of the court on the project of securing social and legal sanction for such choice and relationship has to come only by recourse to discourse on Special Marriage Act or to be confined only to that. The question of altering the text of the statute by any process of interpretation can arise when, in the absence of such an alteration, the stated purpose of the law may not be effectively realized. In other circumstances, such an alteration or supplying meaning to the text may arise when the statute is thought to be read on as to save the law from being invalid. On the statements about the Special Marriage Act made above, it is submitted the law is not expressly or otherwise unconstitutional. A law not being unconstitutional, the question of reading down or reading in may not arise. The importance and desirability of securing to all non-heterosexual persons social recognition and enjoyment of rights and responsibilities, whether available to persons in marriages sanctioned now by law, while deserving of great attention, such a project of securing equality of status and treatment may not be best achieved by the judicial act of erasing out the fundamental features attached to the conception of marriage under the Special Marriage Act, nor it can be realized by the mere substitution of a few words and phrases in the Special Marriage Act 1954. Such an exercise, howsoever desirable, and without further full-length
So you've dealt with also the argument of under-inclusion, that the fact that the Special Marriage Act was intended to be a special law in the context of the conventional institution of marriage, as understood to include a heterosexual union, and to provide a platform for people who are otherwise not able to marry because of their different religious faiths. But same-sex couples were not really ever intended to be a part of this law, and this would not just involve tweaking of this law, but a whole host of legislations on the subject. You formulated it very succinctly. We've seen that, Mr. Attorney General. So
Yes, I just complete.
should we go to the additional submissions now?
And
There-
then go to the.
Yes. Which part would you like to?
next,
What do you want to say?
I was reading at paragraph 11.
Paragraph
11.
11. Yes.
While consequential dimensions, Lordships have that paragraph.
Yes.
While consequential dimensions and their spread or complexity may not by themselves be a reason to detain constitutional declarations, but declarations require redesigning of several measures for their fullness of effect. The declaration may have to be addressed with the parliamentary process. Then the Special Marriage Act as submitted above is not a law with reference to sex. It's a law with reference to the institution of marriage. It's also not a law which is focused on sex directly or indirectly. Having regard to the purpose of the Special Marriage Act, if there can be no fault on grounds of under-inclusion, there can be no fault to vis-a-vis Article 15(1) of the Constitution. Only when the state action, including a legislation, proceeds to discriminate unions of persons other than heterosexual relationships in the context of any social benefit, claim, advantage, interest, etc., it can fall foul of Article 15 of the Constitution. The Special Marriage Act does not contain any such discriminatory intent to deprive non-heterosexual union from the enjoyment of the above said. The doctrinal propositions emanating from so-and-so, that canvass the equality
Just
of
1
treatment and are further reinforced.
Just 1 minute, Mr. Attorney.
Yes, Mr. Attorney General.
Before I read further, Lordship may request take my second note. I may come back to these paragraphs so that I have little connection.
Mr. Attorney, this is exactly what I was saying. Your second note, para 3.
It's an additional
states-
written submission.
I said,
Para 3 actually.
you see, read para 3 of your additional note. I think that's what you want to say in amplification of this. Para 3,
Engrafting and migrating these
page
constitutions.
2, para
August
3,
Para 6.
para
Three.
3, engrafting and
Page two.
migrating. these
Yes, yes,
concepts.
yes.
Please read that. I think that summarizes your whole position.
That's why I thought I'll read that and come back
Yes,
to
please
this.
read.
May I read from paragraphs 1 onwards in my additional written submissions?
Para 1, of course, we've
Those
seen
are
it actually.
well-known.
I understand that.
Marbury,
I know.
Refer to Marbury, then the original intent doctrine.
Expansive reading, 14th Amendment, on-field versus whatever. I think para 3 is really
3 really sums it up. there.
starts your
Para 3 of your additional.
Let me read paragraph 3, yes.
Yes.
Engrafting and migrating these constitution-specific issues to all constitutions will necessarily be an exercise subject to the rules and contents of the relevant constitution and the principles fundamental to the integrated working under the constitution. This means the balancing of social and political processes ordered through representative democracy and the interpretative task, with any tilting becoming a matter of disproportionate acquisition of authority. The basic structure doctrine is also a proportionality doctrine, while its features are inviolable. Making of any constitutional declarations will bear this in mind, and particularly when courts are themselves called upon to convert declarations into working norms. That's a very important aspect of what a court is called upon to do in matters like this. It's not a Vishaka simplistic statement. So let me come back to my other written submission. Before, I would like to read a few parts of my additional written submissions. I was reading.
Mr. Attorney, if you could read para 7 again, because then we can leave this note and then come back.
Yes.
Para 7, maybe if you can. The idea of retrieval of a meaning. In your additional note?
First note.
Yes. Isme abhi.
I said additional.
Additional.
This idea of retrieval of a meaning hidden.
Paragraph 6 and 7 of.
Yes, certainly. 6. We can see 6 as well.
The course adopted in Vishaka was the state of Rajasthan cannot be replicated here, both for doctrinal and practical reasons. No vacuum can be attributed to the Special Marriage Act. Absence of references to all possible unions of persons as marriage cannot be construed as a legal or a constitutional omission. The idea of retrieval of a meaning hidden in the text of a statute, discovered by a process of interpretation, though debatable, that idea comes from an interesting article by Joseph Raz. And retrieving, you're not retrieving something when it is not. So it's different from the idea of adding a new meaning to an existing provision of the statute by reasons of social changes and developments. In other words, adding sense to an existing provision of a statute to make it workable, consistent with its enacted purpose and objects, is different from adding an altogether new dimension to the statute. Whether this would be the result of constitutional demands or otherwise should not make a difference. Consequently, in all situations when constitutional declarations are sought to be made sans a relevant statute under challenge, would call for necessary social adjustment and changes in the social order, and thus call for statutory interventions on studied basis. The court would defer to relevant consultative processes to be undertaken in accordance with law. The spread and depth of the issues involved thus call for a wide consultative process to be set in motion. The consultative process touching upon the Civil Partnership Act 2013 in UK is an illustration of the need and importance of such consultative process. Given the importance of the subject from the point of view of those of discrimination and unequal treatment grievances, as well as the larger social fabric, national consultative process and parliamentary process are desirable. Just as constitutional declaration touching upon important areas of life enhance the scope and content of fundamental rights and add strength and vigor to the free exercise of those rights, democracy with its inbuilt consultative process is also of equal importance as part of the basic structure of the Constitution. Therefore, submitted in independent and exclusive exercise of the Honorable Court in drafting a scheme of rights and interests on the basis of declaring that the concept of marriage as the union of heterosexual is constitutionally and legally deficient and must be rewritten to comprehend any union of persons and conditioned by any sexual factor. Orientations would be anathema to the separation of powers and thus in breach of the basic structure of the Constitution. In fact, I place on record the extensive consultation project that happened in UK on the Civil Partnership Act. I place it as part of my compilations. Compilation number 1, I think. Compilation number 2. Yes, in compilation, there are 2 compilations.
Yeah.
Compilation number 2. I don't propose to read all that in extenso, but Lordship will just make a note of that. Your Lordship have my,
Yes,
it's called compilation to Attorney General's.
yes, we've got it.
Right. If Your Lordship will please look at the index. The first 4 materials. First is the Government Equalities Office, March 2002, a consultation paper. And then there was an impact assessment, which gave a lot of insights and questionnaire and so on and so forth. Then in 2014, there was a report on these conclusions. The report and conclusions does not reach an unequivocal view on whether the Civil Partnership Act should be retained or not, whether it should completely merge with the Marriage Act or not. Therefore, it remained inconclusive. But some of the perspectives give us some insights at how the consultative process was found to be very important and how that also gained a lot of insights on how you look at the wide range of concerns and issues at what somebody called the pathos and the pathology of some of these matters. So, where is my, if you also will kindly turn to page 107.
It must be the running page.
Yeah, yeah. 107.
Yes.
Printed page or the PDF?
In printed. Guidance.
This is that act.
Quality and
Marriage
This is
Same-Sex
the-
Couples Act.
Act 13.
Equality and Human Rights Commission, UK. Kindly turn to page 109.
Yes. Yes, no, that's the article actually.
It's an article.
Introduction. The Marriage So-and-so Act extends to marriage to same-sex couples in England and Wales. Guide explains the changes introduced by the Act and how it relates to equality in human rights law. It complements our accompanying guidance on the workspace, so-and-so, so-and-so. Then second paragraph, rights under equality law protect against unlawful discrimination and harassment based on various protected characteristics, including marriage and civil partnership, religion or belief, sexual orientation, gender reassignment. Human rights also provides protection against discrimination, enjoyment of certain rights, and protect the rights of freedom of thought, conscience, so and so. Then key points.
Mr. Attorney, then what
I
is
don't
the,
propose
what
to
is the,
read it in extent. So I thought these are why I placed
you
it
have,
record.
you have emphasized that there was a lot of,
Importance
there was a
deliberation
process.
consultative process, deliberations.
It may
Fair.
bring to fore a reconciliation at the social level.
All right.
It may also
You're aware because both sides,
Absolutely.
this was put to us.
absolutely.
This act was preceded by a Civil Partnership Act of 2004.
Oh.
So the social process of assimilation of this relationship, how it worked out through parliamentary process.
You're also right.
Thank you so much, Mr. Attorney General. Both your notes were very comprehensive. Thank you.
I have placed and recorded in both compilations, compilation number 1.
Yes. Article by Mark Tushnet.
It'll probably absorb a lot of your lordship's time if one has to go in great depth in many of these. But I thought important to bring how the movement of interpretation is, of course, an absorbing subject. Interpretation of statutes and interpretation of constitution. Somewhere some lines merge, somewhere some lines deviate. So particularly, for instance, if you look at compilation number 1, serial number 7 is a contribution by Professor Tribe in a book called The Invisible Constitution. And it's a very interestingly title called Soundings and Silences. I'll just read a few pages from that. But next comes Lord Sumption's recent lecture, The Limits of Law. And why I thought also I want to put serial number 9, which goes back to the early Montesquieu Benthamite period on how power gets cloaked in the process of interpretation of constitutional provisions, particularly in the US context. So these are expressions to show how you look at the same act of interpretation from different angles and perspectives. May I just read by way of a contrast. I've also placed a record at page 146 of this compilation.
He's quoted the Tribe quotes.
In Europe, in UK. So
I must do a karaoke one. Yes.
I'm not, by placing this, I'm not taking a stand either way. I'm trying to look at how the law looks at it and how perspectives vary in a wide range of the spectrum, one end of the spectrum to the other end of the spectrum. So this article I thought to place in record where the author not only looks at the fundamental misconceptions and then all those which go to reluctance to acknowledge the emerging institutions of marriage. Particularly, it also looks at, I lost to draw attention to pages 161 to 163, where the author looks at guidance and marriage, home, spouse, etc., and how you need to look at them very differently. But thereafter, at pages 289, page 168, that chapter 6, it also looks at the other aspects of what happens within such unions and associations. So you look at a kinship, a family, and look at it either way, the wide range of factors which may enter into the working of these unions and relationships is thought to be presented from a very holistic perspective. I was referring to Professor Tribe's Soundings and Silences. It's a very interesting piece on how silence can be said to be sounding and sounding can be said to be a silence. The last what is that?
You've given us plenty of reading material for post 19th May.
And something to listen.
Listen
Yes,
as
that's
well.
right.
You brought Tina Turner also. What's home got to do with it?
It's a twist, no?
Twist to the.
And Simon and Garfunkel.
Simon and Garfunkel.
That's what we were noticing.
Cited that at the beginning of his chapter. The sound of silence. Hello, darkness, my old friend.
I don't propose to read it
Comes
yet,
to
like this, but
again.
there are
The visions
very
of
good pickups which we can
Well, I
probably
sleep.
carry home from Tribe's article. Only few in the next piece, Lord Sumption's is a lecture given by him and a whole book written on.
Yes, Lord Sumption.
Yes.
May proceed. If Lords will turn to the next art, page 218, that lecture by Lord Sumption, just make a note of only 2 or 3
Limits of the
pages.
law.
18.
There's
Where
limits of the law.
the subject is initiated. At page 219, the third paragraph, there is a second reason why we need to think seriously about the proper role of judges in the ordering of society. We live in an age of unbounded confidence in the value and efficacy of law as an engine of social and moral improvement. The spread of parliamentary democracy across most of the world invariably being followed by rising public expectations of the state of which the courts are a part. The state has become a provider of basic standards of public community, the guarantor of minimum levels of security, and increasingly the regulator of economic activity and protector against misfortune of every kind. The public expects nothing less, yet protection at this level calls for a general scheme of rights and a more intrusive role for law. In Europe, you regulate almost every aspect of employment practice and commercial life, at any rate so far as it impinges upon consumers. We design codes of safety regulation designed to eliminate risk in all the infinite variety of human activities. New criminal offenses appear like mushrooms after every rainstorm. It's been estimated that in the decade from 97 to 2007, more than 3,000 new criminal regulatory offenses are added to the statute book of so-and-so. Turning from a statute to common law, a wide range of acts which a century ago would have been regarded as casual misfortunes or as governed only by principles of courtesy are now actionable torts. This expansion of the empire of law has not been gratuitous. It's a response to a real problem. At most fundamental level, the problem is the technical and intellectual capacities of mankind have grown faster than its moral sensibilities or cooperative instinct. Same time, other restraints on the autonomy and self-interest of men, such as religion and social convention, have lost much of their former force, at any rate in the West. The role of social and religious sentiment, which is so critical in the life of society, has been largely taken over by law. So when Lord Nicholas spoke in Spectrum Plus, the judiciary's duty to keep the law abreast of the current social condition expectation, he was making a wider claim for the policy making a role of judges than he realized. Popular expected law by historical standards exceptionally high. So it is in that, then
You may turn to 223. I think you may want to read that. That's perhaps what you're driving at. This approach has transformed the convention from safeguard against despotism.
page 229, the last part of the lecture.
Looks like it's raining.
At Title of the first paragraph. The court, the sentence beginning, the court being dependent, lordships have that sentence. The first paragraph, line about 10 or 12, 11 from the top.
Which page are you referring to? 229.
229, Lord. Roger Scholar has got that page?
Court being dependent in the generality of cases. Is that what you're reading?
Yeah, there's about 10, 11 lines from the top. The sentence, the court being dependent in the generality of cases on the material and arguments put before by the parties is likely to have no special understanding of other areas. Law and Fuller firmly described this as polycentric problems. What he meant was that any decision about them was like to have multiple consequences, each with its own complex repercussions for many other people. We may visualize this kind of situation by thinking of a spider's web. He wrote, a pull on one strand will distribute tensions after a complicated pattern throughout the web as a whole. In such a case, he suggested it is simply impossible to afford a hearing to every interest affected. 1 out of 3 consequences follow, sometimes all 3 at once, so on and so forth. Now, next. I don't propose to take your lordships to all these compilations at length. There's a
You're giving us something, Attorney? You're giving us something? Mr. Attorney General,
before I go further, yes,
anything
I'm sorry.
further? You are giving us some?
This is a judgment of the Supreme Court of New Zealand, post Guyton, and just read few passages from that. You'll also kindly pick up my first written submission. I'd like to read 2 paragraphs from this, the first written submission.
Yes, we have it.
How do you give it? I'm sorry, this judgment I picked up in the morning and could not have been mailed. page 6 of my first note.
Something to do with drugs, no?
Yeah, it is something. to do with
I just want to read paragraphs and come to the judgment.
Page 6,
Para 6. no?
Page 6, paras 15 and 15, 16 and 17.
17. Yes.
Will not have that page.
Yes, please.
The interpretative exercise in Guidance Supra in the context of the English Human Rights Act 1998 and the European Convention of Human Rights need not necessarily be seen as a departure from well-settled principles and canons of interpretation. Even if convention-compliant interpretations and constitution-compliant interpretations are treated alike, guidance seen in its totality cannot be treated as a charter for dissecting the Special Marriage Act on the grounds of its incompatibility with Article 14 of the Constitution. The underlying thrust of the Special Marriage Act, that's what guidance talks about, the underlying thrust. The underlying thrust of the Special Marriage Act is its enabling character to enable marriages of certain classes of persons. Beyond this underlying thrust, there is nothing in the Special Marriage Act which can be picked up as a thread for expanding the scope of the law as was done in guidance to unions and relationships other than heterosexual marriages. The range of debates on what constitutional courts can do under interpretative exercises throws light on the evolving dimensions of the functions of constitutional courts. The outer limits of lawmaking through the judicial process are lessons to be carefully drawn to balance democracy and the rule of law, ensuring fairness to all. It's evident that the multifaceted dimensions of the issues, though rooted in the conception of marriage, are not to be addressed only through the prism of the Special Marriage Act, but by a comprehensive standalone law that may deal with the multi-dimensional issues arising out of the claim of persons as an heterosexuals. The issues relating to transgender persons arising out of the transgender persons also stand on a different footing and can be addressed without reference to the Special Marriage Act. I don't propose to respond to details, submissions in detail. As far as the judgment is concerned,
Judgment, you want to turn to para 12 and 13? You want to turn to para 12 and 13?
Right. In this judgment, a judgment delivered by Justice Tipping, this is paragraphs 149. Yeah, then how do we? Oh, that's very, I'm so sorry.
Attorney,
It doesn't
para
have a
12.
running page number.
Para 12.
Para 1.
Para 12. No, please read para 12 where guidance is dealt with.
No, it's very difficult this year.
Is this, attorney, the judgment you have handed over in court or
I'm so
something?
sorry, Your Lordships, yes, sir.
yeah, just now handed over.
Just now you handed over this Paul Rodney Hansen, which is a drug crime related case.
Have you got that, Justice Call?
No, if they can send,
I think there's
It has
some.
been emailed.
I'll have it.
No problem.
You've emailed it to Justice Call?
Attorney,
Just give
what
us-
is the judgment?
What is
you
the
are-
point that you're citing this for? What is the principle? What is the proposition that you are citing this in aid of?
Interpretation.
Very well. What I will do is I'll prepare a short note on this.
No, please, let us understand
What is the
whether we are on the
proposition?
same case. Are we on Paul Rodney Hansen?
Doesn't have a page number. How do you deal with that question?
Don't you have this judgment?
The point
attorney?
is about alternative meaning.
That's right. So
Yes.
please, let's go step by step. You might turn to para 12 of that judgment if you have it.
The one which you handed over to us is Paul Rodney Hansen. Is that the same one that you are referring to?
Yes. Now please turn to para 12. This is where the context is there of guidance.
Okay. Paragraph 12
Yes.
of the judgment, if Lords kindly turn to.
Yes. Where they cite guidance, and then now see para 13.
13.
So,
Despite
Yes.
the considerable authority for this views, I am unable to accept that there is any material difference between the New Zealand and UK model
page number, no?
The last sentence in the para on that page, where fundamental rights are affected, particularly those protected by international covenants to which New Zealand is a party, apparent meaning yields to less obvious meaning under common law presumption,
under common law
protective of bedrock values.
values.
And this is amplified in that alternative meaning chapter, which you wanted us to read from para 1.
That's right.
Correct?
That's right.
Thank you, Mr. Attorney General. Thank you. We'll. Yeah,
And I'll also place a record.
after lunch, who would be arguing? Very much.
Yes.
There's a comparative reading. I also place in record.
Certainly, we'll have a look at
A
it.
lecture by Professor Spiegel and another by on the New
Thank
Zealand,
you.
Australian, UK comparison.
Thank you, Mr. Attorney General. Thank you.
I have concluded.
Thank you. Mr. Dwivedi will resume after lunch.
project, my lord, there's an implement application, my lord, on behalf of an organized society, my lord. It can be kept with the records, my lord, and allowed formally. The views are there, my lord, at para 5 and 13.
Yes, yes, Mr. Dev.
Number 72352 of 2023.
Sure.
Para 5 and 13, my lord, that's all.
Yes, Mr. Dev.
Greatly.
My lord, this is a unique case in two respects. One, that there is an omnibus demand. Same-sex, transgenders of 72 kinds, intersex, genders, third-degree genders, all. So, all, my lord, together, everybody wanting an equation with heterosexual marriage. And for that purpose, requesting your lordships to amend drastically the Special Marriage Act. My lords. And this second is, my lords, that this is a demand, my lords, for equation, not simply set a right to marriage, but a right to marriage at par in the same sense. Now, three questions will arise, my lords. Is there a fundamental right to marry? Is there a fundamental right to recognition of marriage? And is there a fundamental right to equality in matter of marriage with heterosexual?
Which is the second one?
Is there a fundamental right to recognition of marriage? And is there, third is there a fundamental right to equation or equality in matter of marriage with the heterosexuals? And the fourth will be, lords, that if there are all these three rights, then can that be made permissible by this variety of amendments? Just to recapitulate, minutes. One demand was, and focusing on the Special Marriage Act first, minutes. Mr. Rohtagi said, my lord, read husband and wife as spouse, man and woman as person, everywhere, and operate both the schedules at the end of the act, prescribing prohibited degrees for the purposes of accommodating same-sex marriage. Then there was one, my lord, suggestion that 99% of the transgenders could be accommodated as women, or as per claim, whatever they put up. Yet another demand was, my lord, that this will not be sufficient to accommodate the third genders. So add some age which your lordship considers appropriate, either 18 or 21, and make that addition. Now, the learned Solicitor General has taken your lordship through the Special Marriage Act, my lord, and various cases to suggest why all this cannot be done. This is too drastic. And various reasons have been given without reiterating, but adopting them. I only want your lordships to look at Section 4. My lord, spouse is a flexible.
Section 4, sorry, Mr.
Section 4. Section 4.
What is the submission?
The submission is that spouse, grammatically, my lord, may be a flexible word. But if one considers the context of the act, my lord, here the spouse means either the husband or wife. Because the context of this act is heterosexual, everybody agrees to that. Not even the petitioners don't contest that, but except that they want substitutions. And if there had been any doubt, my lord, then B, 2 and C make it further clear. Now kindly look at 12. Section 12. The marriage may be solemnized at the office of the marriage officer or at such place with reasonable distance and so and so. The marriage may be solemnized in any form in which the parties may choose to adopt, provided that it shall not be complete and binding on the parties unless each party says to the other in the presence of marriage officer and the 3 witnesses and in any language understood by the parties, I, A, take the B to be my lawful wife or husband. So a husband-wife relationship. Now, my lords, the contention is that substituted by spouse. Is it a simple substitution, my lords? You set up your claim based on choice, autonomy, dignity, fraternity, and all those. Now, is not, my lord, there a dignity for the heterosexuals, my lord? Because you are asked to substitute this by spouse.
How is the dignity of heterosexuals affected by
No, because, my lord, the relationship of husband and wife is a meaningful relationship since antiquity. Husband, wife, pati,
But do you
patni.
mean to say that by recognizing, we're just testing the argument here,
Yes, yes,
that the dignity of the relationship between a heterosexual husband and wife would be affected by granting recognition to a same-sex couple?
No,
No,
not that.
Mrs. Dwivedi, what you're
Not
suggesting
that.
is by using the word spouse, the argument you're
delete it.
making is it diminishes the dignity of the husband or the wife.
That's.
Who wants
I'm
to
not
be
saying.
called as a
I'm not
husband
saying
or the
because of them you give anything you wish they are
Husband and a
entitled.
wife are still a spouse.
still spouses.
No, but
You want to be called as.
when we say that I take you as a husband, I take you as a wife, you want us to say that I take you as a spouse?
That's not your strongest point.
No, it's
Semantics.
it is.
The first point that you made, about amendments, well taken. I mean, no doubt about it. This part, I think, is.
No, it is, my lords.
See, this
All right, we
is
make a
perhaps
note
you
of it.
My
wrote
lord, the question is now how your lordships or I think, my lords. Please look at it this, my lords. How I take it.
You are referring
How the society, my lord, people who marry every day.
I think,
culture.
Mr. Dwivedi, yes.
Yes.
Mr. Dwivedi, what you're driving at is essentially this, that you're not looking at this form, but you're looking at the traditional form where
Yes.
in almost all traditions, in all cultures, do you so-and-so take so-and-so as husband, do you take so-and-so as a wife? That part is what
Yes.
you are emphasizing.
That's right.
But then the argument, of course, it boils down to how are you diminishing the dignity of that?
No, because, my lord, then every time we go to the marriage officer and we say, I take you as a spouse.
It doesn't preclude you from treating each
No,
other as husband and
but why change it? Why alter it?
Mr. Dwivedi, when you say that I take you as a spouse, that is also consistent with I take you as a spouse who's my wife.
No,
I take you as a spouse who's my husband.
Spouse is flexible. Now your lordships when your lordship substitutes, then it is not in the sense in which it is used in section 4.
So what is that sense? That's the question.
In section 4, the sense as it is husband and wife, because this is the heterosexual marriage regulation. But now when your lordship make all these substitutions, then this act will turn into an act which covers other relations also.
That is a different point. That you made your point. I mean, there can't be any doubt about it. That the acceptance of the argument does require substantial rewriting of the provisions of the Act.
That has been addressed.
That's been addressed.
What I am submitting is that while sort of claiming dignity, you should not inflict indignity. Whether look at it traditionally, culturally, historically, socially. These are very valuable things, may have no meaning, my lord, for the people, my lords, who don't attach value to it.
Brings it out better.
But therefore, in a sense, what you are saying is that, look, marriage, which is recognized by the Special Marriage Act, conventionally understood as a union between a heterosexual couple. And by recognizing anything apart from that, you are affecting traditional values.
So don't dilute the status. Don't, small tinkering.
What is the next point? We got
create a boil in the society.
All right. What is the next point now?
Lord, if your lordship recollect, Lord, in Sabrimala, Lord, the lordship's constitutional bench took a view. And there was a virtual counter-revolution on the ground. And this court, Lord, backtracked and referred the matter to 9 judges, and there was a stay, and we are where we were. Lord, there are many matters of social reforms, Lord, which may appear to be constitutionally this side, that side, but when we try to preparedness of the society to accept that change is also extremely important. Let's not rush. Indian society is always not more in tune with evolution, not cultural revolution. And that too, my lord, a request of cultural revolution through adjudication. China tried, failed. Russia tried, failed. They all had to backtrack, my lord. 70 years of Russian revolution, my lord, then we are back, my lords. Communism gone.
Except with one difference, Mr. Devadi. We have a constitution with an enforceable chapter on fundamental rights.
Yes. But fundamental rights don't operate in vacuum. My lord, they are all meant for ultimately to operate in the context of a society, given society. And that's why I'm averse, my lord, when some of us, my lord, try to cross the seas, my lord, and we try bring Obergefell here, bring, my lord, Fori here. So
no, but Mr. Dwivedi, let's be very clear. The existence of same-sex couples is not something which has been imported from some ocean-going.
No.
It's as much a part of our society as
it's part of society, and there is another aspect which is not looked at. And that is that even though it was there in the society, my lord, at no point of time there was any demand or recognition of marriage for them. That's also equally aspect. They were there. They were given respect. They had dignity. Marriage, my lord, I'll come to that, but marriage, my lord, by itself is not a matter of dignity, my lords. If that were so, then people who are not married, my lord, have no dignity, my lords. It can't be that. People, my lord, who become widowers, my lord, and then they are not married anymore, so they lose dignity upon becoming a widow. It can't be that.
That's not the argument. The argument is not that, people who are single lack dignity, or that marriage is the only source of dignity. The point is about choice.
That's right. So therefore, dignity has no relevance. Maybe equality, maybe choice. You can choose your partner, live with the partner. But if you want to marry, that's a particular social. You are then invoking a particular social institution which is existing in the society. Otherwise, my lord, who's stopping them from forming any kind of association? You marry? There's no law. I would be very happy, my lords, if all these laws are taken away, my lords. But these laws are there to protect the interest of women and children because of the command of Article 15(3), which says that state can make a special provision for emancipation of women. Therefore, these regulations have come in. But dignity, my lord, has nothing to do with marriage. My marriage is not registered as your lordship notice, Lord. So I have no dignity, Lord, that means. I'm not looking for any recognition from any law. I don't want the parliament, etc., Lord. We never want depend on the state. Here, there is a particular reason for demand of recognition by state or by court. And that is that Mr. Rohtagi said that we want to use your lordship's prestige to bring about social acceptance. It's all about social acceptance. Otherwise, make any number of judgments, any number of laws made by parliament, my lord, will not create social acceptance. It is only social evolution in which, my lord, the representatives of people participate. That alone, my lord, can bring about social acceptance. I am not inimical to their relationship. But what is the way about? It's the social evolution involving representatives and not a cultural revolution through court, my lord. In all matters of social revolution or social reforms, your lordships have granted legislators, the parliament, a choice how to proceed. You may deal with one section at a time. All laws need not be all embracing. Sometimes, my lord, the laws are made and tested and experimented in one particular area. It need not be throughout the territory of India. It can be piecemeal. It can be phased. And the phases can have spacing, my lord. Look at the women rights case, my lord. Women got right to maintenance in 1937. It was blown up into a bigger right, my lord, in 56. They become co-parsoner, my lord, in 2005. And even today, my lord, they don't have rights under the Agricultural Reforms Acts.
Section 4.2.
Yes. So therefore, my lords, how many years have passed? There was something said, my lord, that we are getting old and so on, my lord. So, my lord, if it's a cause for which you are battling, all causes, my lord, take time to succeed. And all causes have their martyrs. It's not necessary. Why? It's not an individual thing that I got married, I did not get married. I left the world without getting married. The issue is, this is a cause which requires social accommodation, and therefore Parliament, which has the pulse of the people in hand, are in the best position to decide when to take the next step, what should be the next step, and how should it be brought about. These are sensitive areas where the courts, my lord, as far as possible should keep away and not force things. That's what I'm beseeching your lordship, my lord. Don't force it, my lord. Because, my lord, the whole social fabric can be rent apart. We do not know what consequences will happen or not, Lord. I'm not trying to predict something, but slowness is the way forward in such matters, not speed. As we go in the mountains, Lord, there are always warnings that be slow, else there is danger. Now, Lord, there's another aspect. Kindly advert to section 43 and 44. I'm placing only those sections, Lord, which have not been placed, to the best of my recollection. penalty on married person marrying again under this act. Save as otherwise provided in chapter 3, every person who being at the time married procures a marriage of himself or herself to be solemnized under this act shall be deemed to have committed an offense under section 494 or section 495 IPC as the case may be, and the marriage so solemnized shall be void. Punishment of bigamy. Every person whose marriage is solemnized under this act and who during the lifetime of his or her wife or husband contracts any other marriage shall be subject to the penalties provided in section 494 and 495 IPC for the offense of marrying again during lifetime of a husband or wife, and the marriage so contracted shall be void. So the provisions of bigamy have been bodily incorporated by reference Now, there are two things, Lords. If we substitute wife or husband by spouse, what happens to the application of 494-95? Your Lordship will have to then also say that though this substitution has been done as spouse, still that provision will apply. Now, here also it will be substituted as spouse. So some relationship which is as yet the entire chapter 20 seems to be crafted around a relationship between a man and woman. So do we substitute person here also? Every person who by deceit causes any other person who is not lawfully married to him to believe that she is lawfully married to him and to cohabit.
495
Or 494, my lord, is bigamy. Having a husband or wife living, you can easily say we have no husband, we are not living as husband or wife. Or they may say that there was some strain of argument, my lord, that one of us, we can choose a role. So therefore, my lord, there are two things, my lord. How do we substitute this? It's a criminal offense. Are we going to, by adjudication, create an offense with regard to, by bringing them in and substituting, my lord, here also?
Fair enough, that you've made your point, yes.
What happens to the mandate of Article 20? Offense can be created only by law. So the substitution here is virtually impossible. There's no way. Because even if we assume that you can substitute, we are then creating offense. And there are only 20 petitions here. We are told, my lord, that overwhelming majority wants to get married. I do not know whether they have pondered that all of them want to get married under this act and subject themselves to, my lord, this offense of bigamy. And even if they want to, my lord, it can't be done. But we don't know. Tomorrow, one of them can come and say that, why have you included here? How could you create an offense? So therefore,
Interesting. Suppose
Yes.
Just apropos what you were saying, we were just discussing amongst ourselves.
Yes,
and
yes.
It's not my own, but all of us put together, we've discussed this.
Yes.
Suppose there's a same-sex couple, and in that relationship, one of the persons in the same-sex relationship marries a person of the opposite sex. Then strictly speaking, this provision for bigamy will not be affected at
Apply
all.
to them. As it is not applicable.
So if there are two men in a relationship and one of them marries a woman, there'll be no offense of bigamy. Of conversely, or as Justice Bhatt was saying, suppose there is flip the same situation in relation to a trans person, right? Sorry?
A person who who discovers that he is a transgender person, who's already married, and then wants to enter into a relationship,
Same-sex
and
relationship.
then same-sex
Yes.
relationship.
Yes.
There's no bar then.
And then there are people, my lord, who have fluidity, my lords. What do we do with that, my lords? How do we create an offense, bring them into this?
So in other words, your submission is that in order to take care of a myriad situations, it's really for the lawmaking body to enter upon the.
All these factors, my lord, will have
We got
to
the
enter the
point.
melting pot, my lords.
Yes, Mr. Reddy, you have given us.
Look at the tools available to the parliament, my lords. They have select committee, they can form any other committee. Of course, your lordships can also form a committee, my lords, to go into all that, my lords. But it will be preventing the parliament from doing its job and taking a step before they take.
Any other provision of SMA apart from 43 and
Then
44?
they have the law commission, my lords.
And the attorney generals are sometimes also members of the law commission.
Yes.
First law commission.
The first law commission. Also, our attorney general was, of course, not in his capacity as AG. He was not then the AG, but.
So all these tools are available to.
AG was a member of the law commission.
Yes. Good Shakla.
This adjudication, I would say again, with utmost deference, Lord, is happening, Lord, in the absence of states, Lord.
Absence of?
States. Section entry 5 is in concurrent list. Even if Parliament does not legislate, the states in their own territory can.
You are appearing for one.
I have
You are
appeared, my lord, but my application is still lying. My lords have not allowed it, my lord. As
Oh, yeah. Then what are we doing? But we are hearing you, Mr. Dwivedi.
no, hearing as an intervener, my lord. And pleading with an opportunity is.
So how many Dvedis do we have to hear to get all the states represented? One is good enough, Mr. Dwivedi.
Not even one is necessary, my lord.
There's another one.
There's another one here next to you. How Dwivedi needs to.
No, Dwivedi doesn't mean two, Lord. It means those who have read, those who have
Vedas.
read
Vedas too.
but unfortunately, I have not read even one.
Ah.
And there's another saying, Lord, that Dwivedis are those people.
Three times
Yes.
the Vedas.
Chaube is also, Lord. Chaturvedi is also.
Triparthi. Three times.
It is said that there are certain persons, Lord, who became over ambitious and they wanted to write two more Vedas. So they were punished and they became Dwivedis, Lord. So over ambition is bad. Well, the only other provision which I wish to draw attention to is one of them had been drawn place, that is section 4B2.
That you've already mentioned, 4B2. You just.
It has been mentioned, but read it along with 24.
Any of the conditions specified in B.
24, 1 and 2. And 2, which talks of impotency at the time of marriage, at the time of institution of suit. Just note that, I'm not building any big.
What is the next point, Mr. Dwivedi?
Seek a nullity of the marriage.
Oh, that's all right. Nullity can be sought. Yes. Now, I'm not reading, my lord. I hope your lordship has my written submission, my lords.
Yeah, Kapoor is what he put a point here.
Final written submission.
Second,
We're looking at the final, A's final.
second.
There's one paragraph in the original one. I don't know whether it's in the final one.
Because submissions of learned Attorney General were so elaborate that I had to keep on deleting. And the process, once I deleted some
You may
pages,
want to read page 6, para 8. I thought that's a very interesting.
Final written submissions, right?
It's fine.
Finally.
Para 8.
Printed or final?
yes,
I mean-
para 8.
Para 8 is that.
That's it. Although in para 7 also there is one judgment, my lord, but the number of your lordship will see that. In para 8, I have extracted para 39. That was in the context, it's a constitution bench judgment. Section 8(4), my lord, before it was declared ultra vires. Opens with the word notwithstanding anything in subsection 1, subsection 2, or subsection 3, and it applies only to.
This was the Chief Minister 6 months ago.
Yes.
Yes.
Sitting members of legislatures, there is no challenge to it on the basis that it violates Article 14. If there were, it might be tenable to contend that legislators stand in a class apart. In any case, if it were found to be violative of 14, it would be struck down in entirety. There would be and is no question of so reading it that its provisions apply to all legislators and non-legislators, and that therefore in all cases the disqualification must await affirmation of the conviction and sentence by final court. That would be reading up the provision, not reading down, and that is not known to law. So,
down.
Yeah.
Lord, so just by way of side note, if one of the monitors could be in front, my lord, we could see Justice Call, my lord.
It's not.
Oh, you're not able to see Justice Call?
This is very side, my lord.
All right, we just, we'll get it, yes.
If there is some, then it will appear.
Certainly we'll get it done. I'm sorry, I thought you could see.
I'll put it in front of me, ma'am.
Can't we switch the screen?
Is there, no?
You can bring the screen.
तो हम देख नहीं पाएंगे फिर lawyers को देखनी है हाँ you can bring Justice Call on the
That's right.
other side on the other
If there is a.
Justice Call is the focus of attention right now.
Mr. Dwivedi doesn't like a side look of mine.
Some profiles are straight.
Overall personality, my lord, is great.
Actually, ideally it should be there somewhere. Should be there somewhere.
Yes.
Fine. Is it better?
That's right. So that maybe in this somewhere here in the corner.
to keep seeing at the bar and
Is it better on your screen now?
Yeah, I can now.
एक हमारे लिए तो होना चाहिए मैं कह रहा हूँ उनके लिए एक होना चाहिए.
Close up view is it. So, my lord, they briefly touch upon three aspects, my lord, now. That is, Mr. Kripal said, forget the original legislative intent. This court has discarded originalism. And then Mr. Vishwanathan, my lord, referred to Nakara line of cases, my lord, to say, to buttress the submission that alterations can be done. Mr. Singhvi referred to Ghedan, my lord, Ghedan has been dealt with, my lords, already. Now, with regard to originalism, my lords, my lord, the Chief Justice, my lord, had in para 251 and 262 of Puttaswamy, my lords, your lordships made some observations, my lords. I think, my lord, this leads a little more clarity, my lords. In what circumstances, my lord, originalism can be discarded, my lord? Because to say, my lord, that originalism, my lord, is courts are not bound at all, my lord, then in every case we can just forget, my lord, what the legislative intent is or what the framers had said. Whereas in Puttaswamy, my lord, the Chief Justice, my lord, even while saying that there are certain, your lordships have very carefully, my lords, headlined this portion by saying limits of originalist interpretation. This is not the volume 1, compilation 4 of the petitioners, PDF 567.
Have you quoted those two para 295, 296?
No, that's not quoted.
No, it is, isn't it? Para 15? You're not referring to 295, 296?
That's on another aspect.
Not on this. So what
Not
paras
on-
are you referring to, please?
This is para 251 to 262. And it is PDF 567. Constituent Assembly and privacy in limits of originalist interpretation. May I place it? The founding fathers of the Constitution, it has been urged, rejected the notion of privacy being a fundamental right. Hence, it has been submitted that it would be outside the realm of constitutional adjudication for the court to declare a fundamental right to privacy. Argument merits close consideration. Then your lordships have quoted, my lord, from 252 to 258. Kindly come to the last 4 lines of 258 at PDF 570. From this, it cannot be concluded that the Constituent Assembly had expressly resolved to reject the notion of right to privacy as an integral element of the liberty and freedoms guaranteed by the fundamental rights. So it did not really involve, my lord, any rejection of the original intent. Then in 259, the Constitution has evolved over time as judicial interpretation led to recognition of specific interests and entitlements. These have been subsumed within the freedoms and liberties guaranteed by the Constitution. Article 21 has been interpreted by this court to mean that life does not mean merely a physical existence. It includes all those faculties by which life is enjoyed. Then your lordships trace all that. Lord Cooper is there in 260. I'm not reading that much.
Interpretation of constitution cannot be frozen. So
No, that's right. It can't be frozen. Then in 261, 262, technology, etc., has been mentioned. Now, what is being said is that the fundamental rights, my lord, have got penumbras. They have, and as time advances, new technologies come, then new rights can be read into it. Now, this originalist, the limitations are being considered in the context of expansion of fundamental rights alone. It has nothing to do with interpretation of legislative enactments, where n number of judgments have stated that the court's task is to discover the legislative intent and the object and to take that interpretation which advances it. So this is discarding of originalism, my lord. That is the original view. That is the original view of the framers of the Constitution, is resorted to in rare circumstances and because of very strong elements, my lord, which may be present. For example, my lord, in Skora's case, when your lordships brought in the idea of independence of judiciary as a basic feature and collegium, my lord, was born, then it is because of the basic structure doctrine, my lord, which was applied, independence of judiciary was applied, and therefore, my lord, your lordships discarded what Dr. Ambedkar had said. In the assembly, my lord, it was somebody had said that but this will lead to concurrence. Even consultation can be interpreted as concurrence. But that was rejected by Dr. Ambedkar. That cannot be. However, my lord, in Scora, your lordships discarded it, but that is because of a subsequent evolution of a very important aspect of constitutional law, that is the emergence of basic structure, my lord, in Keshwanand Bharati. So that was the reason where your lordship did. But look at what your lordships did in this case.
That is virtually within the.
The legislative intent
Known as
at the mere asking would be, my lord, committing that act which Justice Cardozo, my lord, has warned the judges are not a knight errant roving at pleasure, my lord. So we can't just pour anything we wish. Then how do we do it? Then we have to, my lord, perforce go back to the legislation and discover, my lord, what is that legislature wants to do, and then some iron out some crease, do some chiseling, do some minor surgery, not a major, my lord, surgery. Now, very importantly, what my lord the Chief Justice has himself, my lord, dealt with regarding due process. My lords will recollect, my lord, that this point was raised by me only because, my lord, Justice Nariman had in some judgment said that because of Menaka Gandhi, my lord, and
You brought in substantive due
it
process.
has full circle now. So we are back to due process. So that was the point raised in which your lordships have. Paragraph 273. I have quoted that, but if your lordship...
I think I cited the Oxford Handbook of Constitutional Law, isn't it? Just see one of the footnotes there, I think. Just
Sorry.
around there, I cited the Oxford Handbook of Constitutional Law,
Yes,
I think.
yes. Now kindly see 273, my lords, the PDF 578.
Just read it out, yeah.
There's only one error which your lordships committed, my lords.
I can correct it. I have an opportunity now.
No, I don't think it can be corrected. During the course of the hearing, Mr. Devedi, learned counsel appearing for state of Gujarat, my lord, I never appeared, my lord, but I can probably now send the bill, my lord, too.
Who were you appearing for, Mr. Devedi?
I appeared for Odisha and...
See, even your junior is not agreeing with you.
The lordship then traces in the history, my lords, of this due process in para 274. And finally, your lordships have also noted, my lord, how just Mr. B.N. Rao went to and met
Justice Frankfurter.
Yeah, Justice Frankfurter, and how the changes were sought to be made, and Dr. Ambedkar, my lord, observation in para 278.
Alladi 277.
And in 278, at the end, your lordship says the amendments proposed by some members to reintroduce due process were rejected on 13/12/1948. So several attempts to bring it back, they were repelled. Having noted that, then your lordships even noted Justice Krishna Iyer's observation in paragraph 282, where he said, "True, our constitution has no due process clause or the 8th Amendment, but in this branch of law, after Cooper and Menaka Gandhi, consequence is same." This was also noted. And then in 292, significantly, your lordships depart from what the US position is. The lordship said, in dealing with a substantive challenge to a law on the ground that it violates a fundamental right, there are settled principles of constitutional interpretation which hold the field. The first is the presumption of constitutionality, which is based on foundational principle that legislature which is entrusted with the duty of lawmaking best understands the needs of society and would not readily be assumed to have transgressed a constitutional limitation. The burden lies on the individual who asserts a constitutional transgression to establish it. Secondly, courts tread warily in matters of social and economic policy, where they singularly lack expertise to make evaluations. Policy making is entrusted to the state. Then the lordship referred to doctrine of separation of powers, which is also sometimes misunderstood as if it is only one way, my lord, creating an independence of judiciary. Whereas, my lord, even going by the founder of this philosophy, Montesquieu, my lord, it is the freedom of independence of all three organs. They are co-equal. He says, my lord, a very significant expression that the interplay between these organizations is one of dissonant harmony. So there is some rubbing against
Friction.
some corrections, some checks, some balances, but ultimately they exist in harmony. The lordships have quoted that in Justice Patanjali Shastri's was
The last
observation.
part of it is what you are actually.
Yes, 295, 296. Your lordship,
No, in 293.
I'm sorry.
The last part of the extract, apart from that classical test
Yes,
of what is reasonable,
Reasonable.
in evaluating such
Elusive.
in evaluating such elusive factors and forming their own conception of what is reasonable, in all the circumstances of a given case, it is inevitable that the social philosophy and the scale of values of the judges participating in the decision should play an important part. And the limit of their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint and the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all, and that the majority of the elected representatives of the people have, in authorizing the imposition of restrictions, considered them to be reasonable. The court, in the exercise of power of judicial review, is unquestionably vested with the constitutional power to adjudicate upon the validity of law. When the validity of law is questioned on the ground that it violates a guarantee in Article 21, the scope of the challenge is not confined only to whether the procedure for deprivation of life or personal liberty is fair, just, and reasonable. Substantive challenges to the validity of laws encroaching upon right to life or personal liberty has been considered and dealt with in varying contexts such as death penalty and mandatory death sentence and other cases. Person cannot be deprived of life or personal liberty except in accordance with procedure established by law. Article 14 as a guarantee against arbitrariness infuses the entirety of 21. Then leaving that, kindly come to 295 and 296, not from the sentence beginning hence. Hence, while judicial review in constitutional challenges to the validity of legislation is exercised with a conscious regard for the presumption of constitutionality and for separation of powers between legislative, executive, and judicial institutions, the constitutional power which is vested in the court must be retained as a vibrant means of protecting the lives and freedoms of individuals. The danger of construing this as an exercise of substantive due process is that it results in the incorporation of a concept from the American Constitution, which was consciously not accepted when the Constitution was framed. Moreover, even in a country of its origin, substantive due process has led to vagaries of judicial interpretation, particularly having regard to constitutional history surrounding the deletion of that phrase in our Constitution. It would be inappropriate to equate the jurisdiction of a constitutional court in India to entertain a substantive challenge to the validity of law with the exercise of substantive due process under the US Constitution. So Lordship respected the originalism.
No, not really. Not really. What we really had, this was, you're right. You had shown us Justice Nariman's judgment, virtually saying that substantive due process is now a part of our process of judicial review. What we said was that substantive due process in America itself has now become almost a disbanded phrase for this reason, that substantive due process was used to virtually supplant the policy of the legislature. You know, when substantive due process was adopted, that was particularly in the context of the cases in the years of the Great Depression between 1929 and 1933, when Congress was bringing in social welfare legislation such as minimum wage, maximum hours of work, conditions of labor. A lot of those legislations were struck down on the ground that they interfered with the freedom to contract.
Laissez-faire.
Laissez-faire. And therefore, they really, that was a core doctrine of substantive due process. We said this has never been adopted by our constitution.
So that's what I'm precisely saying, that the Lordships refer to what happened in the Constituent Assembly. And then your Lordships took this view that though there is an advancement, the substantive part can be tested, but with all other hedgings in law. But your Lordship said no to due process. This is important also for this reason, that Obergefell strongly relies upon due process. It's not been discarded. The judgment of Justice Kennedy, the majority judgment, relies upon due process. I'm not saying that a similar view cannot be taken, my Lord, if your Lordships, through the route of Maneka Gandhi or other. That's a different exercise altogether. The wisdom of the legislation will not be tested. That even our court has said several times. We will not substitute the views. So in that context, I'm submitting, my Lord, that originalism
comes down to classification.
And I'm requesting.
Exactly.
Fall back on classification. You're
Yes.
saying that, yes, there is possibility in that side, whatever they are arguing, but this is a classification.
Yes.
That's a part of the classificatory process. But the counterpoint there then is, in that classificatory process, you've excluded. One can understand if there was a
I
positive.
appreciate,
risk.
I'll respectfully, my Lord, answer when I come to Article 14, my Lord. I'll present my views. At the moment, I'm only saying, my Lord, that this prayer to discard originalism, particularly in the context of, we are not construing, my Lord, as some advancing some fundamental right here. Question is statute, Special Marriage Act as it has been made, as it exists. Can we discard its intent? You strike down. We have no problem, my Lords. Heterosexuals will have no problem, it is struck down. Our marriages, my Lord, don't rest on any of these laws. They bank on customs and personal laws, and they will revive and we'll take care of it.
They're of different faces. They'll be
Who belong to the same faiths, there is no problem.
Yes.
But those who belong to different faiths, for them it is a loss.
No, my Lord, every faith, Islam, my Lord, Muslim.
No.
If the spouses belong to
Interfaith.
different faiths,
Interfaith.
interfaith marriage.
There is no other legal mode.
So therefore, my Lord, these are regulatory, my Lords. To enable something which is not happening, my Lord, some people are happening, my Lord, this legislature feels, my Lord, that this needs to be some. That's a different thing. But it's not limited to those who are interfaith. Even others can, my Lord, choose and go get married under that act. But they have a choice under whichever, and they don't depend on any form of marriage. Even the form of marriage is not prescribed by Special Marriage Act. And I was reading one of the petition, probably, my Lord, it was Nivedita's petition, my Lord, and they said that they have married, so be it. Lord, people must create their procedures of marriage, forms of marriage. Let it evolve. We have come, heterosexuals have reached here through ages, my lords. Since Navtej, my lord, we are only 4.5 years. It's hardly such a period, my lord, where let the society, my lord, let there be more debate, more acceptance. Let the parliament feel confident that something can be done. All that, my lord, is not before your lordships in any affidavit, my lord. It will be something like a pole vault, my lords. Jumping the phases. Their history is entirely different.
To say there was no law.
America is created by the settlers from the United Kingdom, my lord. Great Britain, the Columbus story. My lords. They are, of course, I don't want to enter into those bigger things, but certainly America is guilty of the worst of crimes, my lords. In the name of humanity, my lords, and they chant all that. We need not rush, my lord. Why? We don't need to. We can reform our system ourselves. We are capable of that.
We have a
With regard to originalism, my lords, then the Nakara line of, I'm sorry.
Brazil or a-
Finish this.
Now, Baha'is are a community. It's a religion, actually. How is their marriage recognized in Indian law?
Well, I'll have to check out this. I'm stumped on that. Bye, bye.
Yeah.
Mr. Dwivedi, roughly how long would you take?
Close, I'll take.
All of us have a heavy board for tomorrow and some very heavy cases lined up. So we were just talking in lunch that maybe we'll rise at 3:30 only to go home and start reading for tomorrow.
It will take time. I'll take about 2 hours.
About 2 hours still. Can you wrap it up in about an hour or so, Mr. Dwivedi, so that
I'll keep.
Tomorrow, of course,
Lordship said
tomorrow
I'll
we are
keep
not
that in
meeting.
mind.
They are meeting now on Tuesday. I'll tell you what our plan is, that by next Wednesday, we should be through with the hearings. So we really appeal to all, you can also really curtail your rejoinder submissions
I'll try to.
so that then you can decide
I'll
after you
keep
who
it
are going
90
to.
minutes, bro. There's a lot.
So,
I've confirmed as just
Yeah.
30 minutes. I made 6 points.
excellent.
We'll be short.
So then should we rise? Should we rise? Because you're going to anyway take a little while. And our only anxiety on Thursday evenings, today is effectively a Thursday evening for us because tomorrow is a miscellaneous.
I appreciate it.
Everybody is rushing home to start reading those 50 odd SLPs for the next day.
I appreciate it.
We'll resume on Tuesday. Thank you.
Great.